It's another opportunity for us to have the Legal Hour show, proudly sponsored by City Law Solicitors. If this is the first time that you are joining us, we do this program every Tuesday in English, and every Thursday in Twi language for all the Ghanaians in the diaspora. Tonight I'm going to look at employment law, because there are so many stuff in circulation about contracts being varied for those who are working from home, people not being able to come to the workplace, employers trying to lay people off, change terms of contract, impose flexibility in the terms of contract. Tonight is your opportunity to learn the law and know your employment right. I am not a counselor, so I cannot counsel you. I'm not a doctor, I cannot prescribe medication for you. And I'm not a pharmacist, but I know the law. And tonight is your opportunity to join me and learn about your employment right. I'm going to look at a very distinct topic tonight, which is variation of employment contract. Whether the employer has a right to unilaterally change the terms and conditions of your employment contract. And by this, I'll look at the Section 4 statement under the Employment Right Act 1996 and all the associated implied and legislative mechanisms that protect employees at the workplace. So please, share the video with your friends and family members. Let them know that City Law Solicitors, we are here to provide free legal advice to the public. And therefore, I'm going to go for a short commercial break. And when I come back, I take my time to take viewers through their employment right. Don't go away. welcome back. And thank you all for joining the show tonight. As I've said earlier, if it is the first time you are joining the show, we'll do this show every Tuesday and Thursday. On Tuesday, we'll do the English section, and on Thursday, read it for all the Ghanaians in the diaspora. Tonight, I'm going to look at employment law. Many times, we looked at different areas of law on this platform. This program is proudly sponsored by CITI Law Solicitors. So we bring you this free legal advice every week, and then we cover different areas of the law. So this program is about you. It's about making law affordable. It's about giving you free advice. It's about giving you opportunity to ask questions during our phone line times, so that you can ask those questions that are lingering in your mind. This is an opportunity to get this free legal advice. Now, the topic for tonight is whether your employer has right to change the terms and conditions of your employment. Now, the reason being that is that I'm sure most of you who work the news, there have been a lot of some of these stuff in circulation regarding employers seeking to change contracts of employment because people are now working from home. Majority of people or doing hybrid work means that they end up saving money by not commuting to the office space, and also saving money by not spending money during lunch time because they can afford to stay at home and be cooking. And therefore, employers are looking at the fact that cost of production, and in fact, a lot of things have become so expensive. And therefore, in line with that, if there is a way they can change the terms and conditions of the employment, then it means that somehow, for a business efficacy or the business point of view in terms of making profit for these directors and for large companies, for these shareholders, that it's in the interest of the business to sometimes change the terms and the conditions of the employment. And most times, obviously, they will be seeking to cut some benefits of employees. Therefore, these employees need to know their right at the workplace. Because if they don't, sometimes they indirectly accept these changes by continuing to work even when the changes have been unilaterally been introduced by the employers. And it takes one to have the knowledge in order to be able to determine or to be able to identify whether the variation is something that is a contractual change of the term of the employment. But of course, there are also legislative instruments. There are statutes. So tonight I'm going to look at variation of contract of employment. And by this, I'm saying that I'm looking at your employment right at the workplace. Now, normally, when we are looking at employment contract, it's important to set the background for lay people to understand. Contract, employment relations is bound by a contract. Whenever we talk about contract, we are looking at offer and acceptance. So the employer offers to employ the employee. And most times when people go for an interview and they are successful, there is an offer of employment. So the employer writes to the employee and says that, I am happy to announce to you that you have been successful in this interview and you have been offered the role of a manager, or or you've been offered the role of a supervisor, or you've been offered the role of paralegal staff. So you realize that that offer needs to be accepted by the employee. And in most cases, most employers will say that if you accept this offer, you have 5 days to sign it and return a copy of this contract to us. So once you sign it, it means that there have been an acceptance of that contract. And that acceptance means that that person has considered the terms. So that's what they call consideration. So you have considered all the terms in that employment contract, and you have therefore accepted it. And there is an intention to have legal relationship, which means that you can end up being sued for breach of contract. As an employee, employer can be sued for breach of contract because there is a legal relationship. And above all, there is what they call certainty of terms or obligations. Now, I don't want to bore you with all these legal jargon, but all that I'm trying to explain is that employment relationship is a contract. And whenever there is a contract, there can always be a breach of that contract. So, in most cases, the distinction between ordinary contract and employment contract is the fact that in addition to the terms and conditions of the employment, there are other mechanisms that are also in play. For example, there is a statute. Whenever anybody is working or has been employed, that person has a statutory right to annual leave, which for those people who work full-time, 20 working days. There is a statutory right to statutory sick pay. So this may not necessarily be in the terms and conditions of the contract, but they are statutory right that forms part of the contract, whether they are stated explicitly or not in that contract. And therefore, when you are looking at the contract, and I want viewers to listen very attentively, because I always say that each time I'm in this studio doing some of these shows, it's because some of these things are becoming very rampant. I've had people who are sending me snapshots of changes that are taking place at their workplaces. Some, their pays are being reduced, their hours are being reduced, and they don't know who to turn to, and they don't know their right. Because most of those changes that are taking place at the workplace, quite clearly, are breaches of the terms and conditions of the contract. And this might not even involve in somebody doing cleaning job. In fact, it goes all the way to the top. There was one of the cases that we were dealing with, where a whole renowned organization, in fact, diplomatic organization, who was seeking to unilaterally change the terms and conditions of employment of the staff, including the pension scheme, without engaging in pension consultation as a statutory right of the employees. So you see, a whole lot of stuff go on, and because employees don't know their right, they allow employers, in fact, to undertake most of these changes unilaterally. But even employers, they also need to know their right, so that employees doing certain things at the workplace that in a way breach the terms of the contract, they could also rely on them to either dismiss them or pursue a claim against them. And tonight I'm taking my time gradually because I'm building the background of contract of employment. And eventually, I'm going to be able to look at the specific terms of these breaches that I'm going to look at when we're looking at variation of contract of employment. So what I'm saying here is that having established offer and acceptance of the contract of employment, which has then become a binding document between the employer and employee, then whenever there are going to be certain changes. Now, normally, when changes are taking place, those changes can be due to varied reasons. For example, the employer might seek to change the hours of work. So if AMA is, for example, working for 20 or 40 hours, they might seek to decide that, well, for one reason or the other, they want to change that contract of employment and the terms. Or it could even mean that what they call mobility, where one is working at a branch A and there is no mobility clause in the contract and it's being transferred to branch B. It means that under those circumstances, the employer needs to do the following. She needs to seek explicit agreement from the employee. So let's say I am working from, for example, Chelsea, and I'm being asked to go to a branch in maybe Woolwich, and there is no mobility clause in my contract of employment, then the employer is not entitled to undertake that transfer. It means that any transfer that takes place under the mobility clause needs to be something that the employer has sought my explicit agreement to the change of that transfer. Otherwise, it will be a breach of what they call the contract term. That's one example. But more importantly, that same mobility clause, because I'm looking at statute. So for example, if you are a parent with younger children, then it means that if the employer is seeking to transfer you against your will from one branch to the other, then this act can also come into play. It means that that could also amount to discrimination. The reason it's discrimination is that it could affect that parent's right to taking his children to school because he probably have to travel a longer distance. So you see that even though this might be something that is contained in the contract as a mobility clause, it might be in breach of what they call the Equality Act 2010. So I'm looking at those on maternity, for example, and those with parents with younger children. So when those changes are taking place, it could affect their right under the Equality Act, mainly discrimination. So that's one example of looking at this variation of contract in terms of mobility clause. But notwithstanding, there are various changes that take place. So the question is that when a change of contract, recently I heard from the news, from various media houses, that some employers are seeking to ensure that they can even reduce the pay of some of the staff because they are working from home and they are saving money. And the reason why most of these changes are now taking place is the fact that pre-COVID period, most of us were going to the office almost every day. And then during COVID, people were asked to work from home. So you find out that most of these employers have been tied into sometimes commercial leases, and they are paying huge sums of money for these offices, and no one is coming to the office to work. And because no one is coming to the offices to work, sometimes, according to some of them, it affects their productivity. It means that one way or the other, people who are staying at home perhaps may end up saving more money. So the argument is that if that is the case, they might seek to change the terms of contract in such a way that they can end up cutting some of the wages. Again, if that was to happen, then it means that that employer who is seeking to bring in those changes needs to at least seek the explicit agreement of the employee. If that is not complied with and the employer unilaterally make those changes, then it becomes a breach of contract. So, having said that, if it's a breach of contract, then what is your right as employee where there has been a variation of contract that has been changed to the terms and conditions of your employment? And even though there is no statutory right to employment contract, and I want people to again make note of this, there is no statutory right. However, every employee is entitled, it has a statutory right to what they call Section 4 statement. The Section 4 statement sets out your place of work, your wage, your annual leave, your statutory sick pay. So that Section 4 statement, the date you are meant to start work, when you can go on, all those Section 4 statements will set it out. But some employers will give you what they call contract employment. And then they also give you handbook or refer to it in that contract of employment. So in as much as people are not entitled to what they call employment contract, they are entitled to Section 4 statement, which is more or less a subset of the employment contract. But even that, there are things that also occur at the workplace, which in employment law you call custom. So when a practice has been carried out for a long period of time, for example, my employment contract says I should start work at 9 o'clock. And my employer for almost 6 months have allowed me to be working from 11 o'clock or 10 o'clock. It means that my employer somehow have allowed that to become a custom and has become part of my contract. So when changes are being made, it could also cause issues here. But having said all this, I'm looking at what right does the employee has when some of these changes are being made, and especially when these changes are not in favor or they do not benefit the employee, and then the employee want to protest those changes. For example, a well-known diplomatic agency trying to change the pension scheme of the staff. And I remember those times when we were instructed and sent out one letter. They never had any response from them because they were made aware that that would be in breach of the terms of the contract. So sometimes you may assume that some of these employers might not go that far. They either take the employees for granted or they sometimes out of ignorance. So here I'm looking at if you are anybody who is facing some of these what they call detrimental changes to your contract of employment, which means that changes that are negative, changes that do not benefit you, then what is your right? So here, if the employer, I've already set out for those of you who have just joined that this contract is what they call offer and acceptance, and there have been intention for legal relation, and the certainty of the terms have been established. Therefore, if the employer was to make any change, then it has to be something that has to be agreeable to the employee, because there is a mutual relationship between the two. So if any of these changes were to be made without it being agreeable by the employee, then there is a breach. So what is the employee's right? First, the first point is that the employee can agree to that change. If the employee, for whatever reason, feels that that change is beneficial and agrees to it, then there is no problem. The second point, or the second right that employee has, is to continue to work under what they call protest. It means that the employee is saying that I don't agree to this change, and I have not decided to leave employment or to leave this job. I will continue to work, but I'm working under protest because I'm not accepting this change to my contract of employment. So under those circumstances, there are two things that the employee can do, and some of them are quite complex. So let's say there has been a change in your wage or any of your benefits. Normally, the employment tribunal does not have what they call jurisdiction or power to hear a case where one has not been dismissed. But employment tribunal, because employment tribunal normally deals with cases, for example, of discrimination. For discrimination, for example, if it's an ongoing case, you are still working, you can say claim discrimination and still remain in employment. But for unfair dismissal, for example, you need to be dismissed before you can bring your case to the employment tribunal. So when there is a change of term in the employment and you are working under protest, for example, a change that affects your wage or some of your benefits, then it is difficult to go to the employment tribunal. However, you can go on the grounds of what they call unlawful deduction of wages. So it means that you are saying that under your contract of employment, you are meant to be paid this amount. The employer, one way or the other, have reduced the benefit or the wage by a certain amount, and therefore you are coming to the employment tribunal for the employer to pay you back that money. And sometimes we have had cases that people don't know that there is a deadline. Normally you can only claim up to 3 months. So if you continue to work on the protest for about 1 year, then you may be able to recoup just 3 months of that. But people can go into the civil court to go for what they call declarative or declaratory relief, where the court will establish that that change cannot take place. But I don't want to bore people with all these complexities. The second right or remedy to the employee when there has been that detrimental change of a term of the contract, a change that affects you, that you are not happy with, you are very angry that I have made that change. I've already explained the first two. The third one, normally, when there have been that change, then it means that what you can do is that if working on the protest does not work for you, and you didn't agree to the term, then you can resign from employment because of that change that they have brought that is affecting you. You are very angry about it. Not just angry, but because it's not in your contract of employment, it means that you can resign. But when you resign, you are not just going away. You are going to claim what they call constructive dismissal, which is equivalent to unfair dismissal. So what you are going to say in the employment tribunal is that there has been a fundamental change to the term of the employment that have affected you negatively, or detrimental breach of the contract. And therefore, there has been of what they call breach of trust and confidence. And I remember many years ago, one of the cases that I handled, the employer, a white person, had made the workplace a hell for the employee in terms of more or less harassment and discriminatory remarks, racial discriminatory remarks. And our client had to resign from that employment. And after resigning, unfortunately for the employer, he happened to meet us. And quite frankly, the way in which he wrote his resignation, more or less, he was fed up, so he was going to go back to school. But of course, those acts has happened, and there have been meetings here and there, and there were evidence that he was being harassed. And therefore, when we made a claim initially to ACAS, it was refuted, and eventually we went to the employment tribunal, and they have to settle out of court, out of the tribunal, and pay huge compensation. So that's a practical example of somebody suffering from the workplace because there has been a change to the conditions of employment, or there has been a breach of trust and confidence at the workplace, and therefore that person is resigning and eventually claiming what they call constructive dismissal. So that person is more or less saying that, look, I will not have been able to resign if you have not made this change to my contract, if you have not treated me this way, if you have not harassed me. And eventually that person will be entitled to compensation for fair dismissal. And in fact, if there is racial discrimination element or any breach of the equality, whether because that person is a mother, whether because that person is pregnant, whether because that person have disability, whether because that person have different sexual orientation, or because of religious belief, then that could also amount to a breach of the Equality Act. And of course, I always say that the minimum compensation under this remedy is $9,000 and upwards, and people can claim up to about £100,000 or more if they are so breaches and able to show that they have been under stress. So that's one area of that breach and claiming constructive dismissal. But of course, people have to also look at this fourth element. This fourth element, or this fourth point, is where the employer feels that this guy has been so stubborn and I must terminate this employment at all costs. And of course, if they want to continue to work for me as an employer, then they will work under my new terms of employment, because they have refused to agree to the change that I'm bringing to the workplace. And that change for business efficacy will help me to generate more profit. And I cannot allow this stubborn person to stop me from achieving this. So I am going to dismiss that person, or all the employees who refuse to sign this new contract of employment. So under those circumstances, that's what we call fire and hire. Recently, we had from one of those boats on one of those ferry where a lot of people, including the whole crew, being dismissed and being replaced by agency staffs. They went out. By the time they came back, they couldn't board the ferry anymore. Their jobs were gone, and it was circulated in the news for the past 6 months all over the place. And of course, eventually those people would have ended up going to the tribunal, but that company was quite wise, so they paid them the compensation. Therefore, even if you go to the tribunal, you end up getting either less than compensation. So even though it was quite immoral, but eventually they succeeded in bringing that change, and they got rid of all the people at the workplace and replaced them. So sometimes employers can undertake those drastic moves by ending the old contract or the existing contract and then bringing in a new contract that has new terms and conditions that perhaps are favorable to the employer, even if they are against the will or the agreement of the employee. So under those circumstances, it's what we call hire and fire. So they will just fire you and then they'll hire you again. So what will happen here is that if you are an employee and then you find yourself in this situation, I've already explained 3 things. The 4th one is what I'm explaining. So it means that 1, you have agreed to work with the employer with a new change that has been introduced at the workplace, which is was not in your contract of employment, or you have either continue to work under protest and disagree to the change, and therefore you can go to the employment tribunal for unlawful deduction of wages or declaratory relief at the civil court to prevent that change. And the 3rd one is claiming constructive dismissal, wherein you can then go to the employment tribunal, because I've said that the employment tribunal will look at your case only when you are dismissed or it's for equality, a breach of equality act, which is discrimination. But the 4th one is where the employer then dismisses you and say that, look, you have refused to accept this change that I want to bring to the workplace, which was not in your contract of employment, but I still want to bring this change. And because you have refused to sign the new terms of contract, I am sacking you. When people are sacked under those circumstances, there is 2 things here that I want people to look at quite cleverly. If there is a change and you have not agreed to that change, then the first point that comes to mind is that it means that you are in what they call a redundancy situation. So if you are in a redundancy situation, it means that you are no longer required. So if you are no longer required, that means the employer needs to pay you redundancy pay. And obviously, depending on how many years you have worked for the employer, especially if it's more than 2 years, then you'll be entitled to some compensation in terms of notice pay and some basic award, which is depending on the number of years you have worked, which is a week gross pay of each year. But the point here is that sometimes people are just dismissed outright without being offered this remedy of redundancy pay. So if you ever find yourself in that situation and you have refused to sign the contract of employment and you have been sacked, the employer should have first considered that by going through what they call consultation, especially if they are seeking to dismiss 20 or more staff for change of terms of employment within 90 days under what they call Trade Union and Relations Act 1992 under section 188. They need to have complied with that legislation. But even that, if you have ended up even being forced to take redundancy pay, then of course, or you are not paid redundancy pay and you have been dismissed because you have failed to again sign that change of contract or terms of conditions, then you are entitled to claim what they call, again, unfair dismissal. That means that the employer has a burden to show that it was reasonable to bring that change to the workplace, and it was quite reasonable for you to have accepted that change. And in most cases, employers will tend to dismiss people on what they call other substantial reason grounds. So guys, for those of you who have been watching, I'm gradually coming to the end of the show, but of course I'm going to give a summary. But before I do that, before I do this always, I need to acknowledge these viewers who are on the show, because they are so important to us. They are part of our community, and therefore I need to acknowledge them. So if you have just joined us, I'm going to acknowledge you. I urge you to make some comments, and then I'll be able to. I have Nasir Lamidi, who is also watching. I have Kofi Bench watching. Now I have Ajoa Aduchumwa, who is also watching City Media TV. I have Gabriel Bankoli, I have Cynthia Ankoma, I have highly favored Priscilla watching, I have Sophia Ashon, who is watching, Ifeura, Big Willie, one and only Big Willie. I have Big Willie also on the show here. I have Riafo Frimpon, who is watching. I have Kweku Tanoku watching tonight. I have Tina Tanaklo, Mabel Opon Mensa, who is also watching us tonight. I think this is the first time she has joined it. I have Dora Frimpon, our regular listener and viewer. I have Esenam Afi Kasa. Esenam probably is one of our new viewers who is also watching tonight. I have Yasmin Hanif. He said, nice advice. Yasmin is also watching. I have Yarrow Man watching tonight. I have Rosine Troa. Sava, merci beaucoup. I have Senior Cook, our promoter, who is also here on the show. I have Ebidila Yao. Osai Bonsu is a well done old saint. Wow, I have some old saint on the show. Right. So guys, you can continue to share the show, let people benefit from this advice. But of course, I must also say that it is so significant that people seek advice, because the employers are entitled to make some of these changes under the flexibility of the clauses that are contained in the contract of employment. So don't say that, Lawyer Thomas said that you cannot change any term of my contract. No. If you look at a contract, I have said that there are mobility clauses, for example, which allows the employer to transfer you from one place to the other. Where there is no mobility clause, the employer cannot do it without seeking agreement from you. But even if there is mobility clause, that is what they call Equality Act 2010, which means that if you are a parent and that is going to cause you inconvenience and discomfort, then that could be a breach of the Equality Act. So the employment law, I always say that it's quite complex. And obviously those of you who have been instructing us to be doing some of this work for you, we always say that these cases are normally very complex. Hey, but above all, if you're an employer and you are getting confused with some of these things, it's about time for you to seek corporate lawyers' advice. So at this point, I'm going to take my time to do a bit of advert for our sponsor, CITI Law Solicitors, which is sponsoring this show. So hey, pardon me to just take you through what we do. CITI Law Solicitors obviously is why I'm here tonight, to give you this free legal advice, this quality advice. And therefore I'm here to also advertise the firm, so that if for whatever reason you find yourself in any of these areas of law and you have problems and you need somebody, you need a helper, then of course you can come to us and we'll be able to assist you. If it's compensation, we'll do this work for you and claim that compensation for you. So, who is CITI Law Solicitors? CITI Law Solicitors is a law firm which is recruited by the SRA and is family law accredited, and we are located at Barking. If you want to look for us, our address is Unit 113 and 122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG11 8FJ. Our office telephone number is 020 33 55 0782. I'm going to repeat this number. 020 33 55 0782. So this is the office number. If for whatever reason you have any legal problem and you need advice, don't hesitate to contact this number. And obviously, our qualified solicitors are ready, waiting for you. Now, if you want to call the emergency contact number, it's 0777 777 210 4967. 0777 210 4967. That is the emergency contact number. And obviously, if you call that number, you end up speaking to me. If you don't want to talk to me, you can call the office number. Right. So, what areas of law do we specialize, city law solicitors? We specialize in numerous areas of law. Obviously, immigration. Immigration is more or less like a hobby. Because one of my friends said that immigration is life. Because whenever you move from one country to the other, then obviously you may have some immigration issues. It doesn't matter whether you are European. I have European clients from France, from Germany, and I have all these indigenous white and all these Europeans. They also move from one country to the other. So they need us as immigration lawyers to assist them. So immigration is life. Because once you have moved from one country to the other, hey, you need to sort out your immigration issues. And we specialize in numerous areas under the immigration law. We do sponsorship licenses for organizations. We do skilled worker visas for individuals. We make applications for people under the EU settlement scheme, even though the EU law is obsolete, but we're still making late applications under the EU settlement scheme, and family permits under the EU law. We still continue to make applications for spouses. If you are falling in love with someone and who is living abroad and you want to bring the person here to join you, man or woman, or man, we are still here to help you to sort out that immigration matters for you. If you want to register to become a British, of course, the good news is that now they are saying that all children under 18 are entitled from the 16th of June 2022 to apply for fee waiver. So their parents, both parents are going to be assessed if they are eligible, and they can show that they are unable to afford to pay to register these children to become British. Then they will get what they call a fee waiver. So if you have a child who is born here, who is 10 years or more, if you have suddenly had your indefinite leave to remain and your child is born here, if your child came from abroad and he has got indefinite to remain, we can apply for fee waiver to register all these children to become British. So that's the good news that came in on the 16th of June 2022. So I want people to take note of that. So we will specialize in the British and nationality law, which is what I've just explained. People who want to become British. Asylum. We'll help you so that you don't end up in Rwanda, Hotel Rwanda, because we'll make sure that we'll guide you through your asylum proceedings. So that's about immigration. Employment law. That's what I've just come here to discuss. We specialize in employment law. If you have a company and you want an employment lawyer to assist you to make sure that you don't become a victim of paying compensation to an employee, they know who to seek advice from. CITI Law Solicitors, we are here to assist you. On the other hand, if you are the employee that has been unfairly dismissed, harassed, you have suffered, you are a victim of discrimination, breach of the Equality Act, if you come to us, we do most of all these cases under no win, no fee. If you don't win, we don't get paid. So you see, we have a common purpose and a common interest. To win this case, it's only at that point that you give us just a little token so that I can also smile and CITI Law Solicitors join you in the celebration of you receiving that compensation. So don't forget that employment lawyers, we are here with you. Family law, if for whatever reason you have a problem seeing your child or children because the relationship has broken down and you want to have child arrangement in place, order in place, we are here to assist you. If that person is abusing you in your own home, or a home that is jointly owned to you, or a home that is even in his sole name, but you are part of that family, and you want to make application for occupation order and now molestation, we are here to assist you. Guys, take note that these days, domestic abuse is criminal offense. So if somebody has made an application under the Domestic Abuse Act 2020 against you, and you want lawyers to defend you because otherwise you may end up in prison, in custody, again, we are here to assist you. We are family law accredited firm, and therefore, when you instruct us, you can always dream of the best service. Personal injury and clinical negligence. Again, if you are involved in accident at the workplace, if you are involved in motor accidents, if you went for treatment and you felt that there was negligence, we can look into it for you, and eventually we can get some compensation for you as well. Again, it's no win, no fee. So we do all these cases on a no win, no fee. Housing law, if your house is in a disrepair state, uninhabitable condition, and you want us to assist you to claim some compensation, again, we do these cases on no win, no fee. Consumer law, if you are a company and for whatever reason you trade and you want us to help you to draft some of these things so that people will not end up taking advantage of your business, we are here to assist. So you see, CITI Law Solicitors, we cover all areas of law. We make sure that we don't only solve your immigration problem for you, but we also solve your employment problem for you so that you can have peace of mind at the workplace. And even where you sleep, if it's in a disrepair state, we are there to help you. If there is a dispute in the family and there is divorce and you want to share your assets, again, we are here to protect your interests. So you are covered. CITI Law Solicitors, your uncle. Thank you so much, guys, for being with me tonight. I'm going to open the phone lines briefly. If anybody has question, any legal question, I am here to answer. The phone lines are now open. The phone lines are on the screen. You can phone in and ask questions. I am not a doctor. I cannot prescribe medication for you. I'm not a counselor. I cannot advise you on how to work out your relationship. But I know the law, and I'm here tonight to assist you. So if you have any legal question, I am here. This is your opportune moment for free legal advice. It doesn't matter, it is something different. As long as it falls within my areas of competence and jurisdiction, I'm going to be able to advise you on this. If it's about employment law, immigration, family law, any legal matter, this is your chance for free legal advice. The phone lines are now open, as I've said. The phone lines are the studio lines that you can call is 0793 2934 518 07932 934518. That's the first. We have two studio numbers here, and then we have another studio number which is 0744 033 8623. I repeat it, 0744 033 8623. So guys, if you have any legal question, this is your opportunity for free legal advice. I am soon going to leave the studio. I've been here for a while. It's been a pleasure. I'm so privileged to have you on this platform tonight, and I'm yearning to give you that advice free of charge. This is your opportune moment for you to receive that. And for those of you who have just joined me, tonight we'll be looking at your right at the workplace. I have some few guys who have just joined us. I have Skipper Gunib. Welcome. We do this program every Tuesday in English and Thursday in Twi for all the Ghanaians in the diaspora. I have Sophia Song, who is saying very educative. We are so happy that people appreciate that this free legal advice is something that most of you benefit from. We are so glad to know that. And if you don't want to phone in and you want to type your question, I think there are some other guys who are also watching on my own personal profile. I always say that if you are watching from my personal profile, I urge you to migrate to the CITI Media TV, because that has become the epicenter. I have somebody who has just come on the phone line. Because that has become the epicenter. Hello, caller. You don't have to mention your name. You can, if you have a question, you can ask.
Lawyer Thomas, I just called to say thank you, and I mean, should I pass also educate now my answer. I mean, passing your chima to the next me that was the minister on your morning DM more. But I just going to the next about me insure, and that's a
Thank you. Hallelujah. Hallelujah. Amen and amen. I receive it. Thank you. Right. So guys, I'm still here. If you want to make any contribution, I'm here. Very soon I'm leaving the studio. And those of you who want to phone in, it's your opportunity to get this free legal advice. And as I've said, in the next few minutes, I'm going to leave the studio. But before I do that, I'm giving you opportunity if you have any legal question. Right. So let me just summarize what I've discussed today. Tonight, I've looked at employment law. I've looked at the fact that normally employment contract is a contract in itself which has these contents: offer, acceptance, intention to create legal relations, and sanctity of terms. So those of you who are lawyers, you know that any contract will have all these 4 pillars, because without it, you don't have a contract. And once there is a contract, then there is likely to be a breach. If you buy a product and the product is going to be delivered by Tuesday, that is a contract. If it's not delivered on Tuesday, it's a breach. So if the contract has terms that forms the relationship between you and the employer, and the employer wants to change it, they need to seek your agreement from you. If they don't do that and they unilaterally change any of those terms that affects you detrimentally, it means that you have 4 rights. 1, if you voluntarily agree, there is no issue. If you don't agree, you can continue to work under protest and claim what they call unlawful deduction of wages, or declaratory relief under civil court. Number 3, you can resign because you are opposing that change and claim what they call constructive dismissal. You go to the employment tribunal, you'll be entitled to compensation. Number 4, the employer may decide that you are so stubborn and therefore I'm going to dismiss you. And then the employer gets into trouble where you say take the employer to the employment tribunal for compensation for unfair dismissal. And I've also said that even with mobility clauses, all these things, things that affects the contract can somehow indirectly be a breach of the Equality Act. Under the Equality Act, we have what they call racial discrimination under Section 9. I always say that discrimination is not just about race and color. It's about nationality and different cultural background or ethnic background. So you can have a Caribbean who has a case against an African. They are both black, but there is a breach of the Equality Act because they are from different cultural background. So I say that some of this bullying and harassment and all this stuff go on at the workplace, trying to force employee to change their location under mobility clause might somehow result in a breach of the Equality Act because it might affect that mother or that employee with young children because it might have difficulty taking them to school. So tonight I've looked at all these areas under the employment contracts and those things that can result in what they call breach of trust and confidence, which could either result in a breach and the employer can be sued for wrongful dismissal, unfair dismissal, or a breach of the Equality Act. 3 remedies that people could be entitled to. On Thursday, MC Chaka is going to be here and I'm going to do this show in Twi. And it's an opportunity for all of us who speak Twi in the diaspora to join the show and learn about our employment right at the workplace. Thank you all for joining us tonight. This program has been proudly sponsored by CITI Law Solicitors. I must say that if you have found this program if any of you have found part of this show to be quite exciting and quite significant and insightful, this program is recorded and you can watch it over and over again on our CITI Media TV or CITI Law Solicitors YouTube channel. It's going to be there. You can watch it again. Thank you. Thank you, and God bless you so much for joining us tonight. Thank you. And obviously, we'll see you on Thursday. Bye-bye. God bless you.